Today, literally everyone in immigration law is talking about this new USCIS memo on adjustment of status. I've probably read it 5 times already, and I want to talk to you about it calmly, not to create panic, but because this could become a very important shift in immigration policy. But conceptually and philosophically, this is already a very major shift. It is way too early to know exactly how this will actually be implemented. We don't know yet how strictly officers will follow it, whether different USCIS offices will apply it differently, whether this is mostly strong language or a real operational change. Or honestly, how in the world parts of this policy would even work in practice. A huge debate is already happening among immigration lawyers because this memo repeatedly says that adjustment of status, meaning getting your green card from inside the United States, is an extraordinary discretionary form of relief. Let's pause here for a second. Discretionary basically means even if you qualify under the law, the officer reviewing your case can still decide whether they think you should receive the green card. And that is where the controversy starts, because Congress specifically created adjustment of status to allow certain people to obtain permanent residence here in the United States without having to leave the country and process abroad. This is literally the whole concept behind adjustment of status. If Congress created this legal pathway, how is it suddenly being described almost like some kind of loophole or extraordinary exception? And what exactly does extraordinary relief even mean in this context? If this policy is applied aggressively, it could potentially allow the personal judgment of an immigration officer sitting in an office reviewing your file to override what Congress made legally available. That is why people are paying such close attention to this memo. Very important. This does not mean adjustment of status is ending. It does not mean everyone's green card will suddenly be denied. But it absolutely signals a major philosophical shift in how USCIS may begin viewing these cases. And we will most likely see major federal litigation challenging parts of this policy, especially if USCIS starts enforcing it aggressively. For now, stay informed, not panicked, because this conversation is only beginning.